Hi everyone, welcome to SQE1 window and welcome to chapter 8 of our SQE1 criminal litigation. Today we are talking and tackling two critical evidence topic, hearsay and confessions. These areas are heavily examined because they involve fundamental fair trial safeguards. Hearsay is complex. Yes, it is. Understanding when out-of-court statement can be admitted requires mastering multiple statutory gateways. At that point, we need to understand a lot. Confessions, meanwhile, involve strict exclusion rules protecting against unreliable or improperly obtained admissions. By the end of this session, hopefully, we will all understand these two challenging areas which are heavily tested. So let's start with the fundamental principle. Best evidence is oral testimony given in court, subject to cross-examination. Why? Because cross-examination tests reliability, expose inconsistencies, challenges credibility, and allows the fact finder to observe witness, how they are talking, what they are talking, and its credibility. Hearsay evidence cannot be cross-examined. When a witness reports what someone else said out of court, we lose the ability to test the original statement. The original maker is not present, so we can't challenge their account, probe their memory, or assess their honesty or hostility. Typical hearsay involves witnesses reporting another person's account or written statement being read without the maker attending court to testify. This is problematic because the person whose statement we are relying on has not been subjected to cross-examination. So what exactly is lost without cross-examination? We lose the ability to test perception. Did they actually see what they claim? We lose the ability to test memory. Are they accurately remembering? We lose the ability to test, the truthfulness. And we lose the ability to test narrative ability. Are they communicating accurately? In exam, it can ask what is lost without cross-examination. That is the ability to test reliability through challenging perception, memory, and truthfulness. So let's talk. So hearsay is defined as an out-of-court statement that is adduced to prove the truth of its content. This definition comes from Criminal Justice Act 2003. In a case, three elements must be present. First, it's a statement not made in the current oral proceeding. Second, it's out of court, made somewhere other than in testimony at this trial. Third, and critically, it's tendered to prove the truth of what the statement asserts. The third element is key. Always identify the purpose of tendering the evidence. If the prosecution want to prove that the statement's content are true, it's hearsay. If they simply want to prove the statement was made regardless of truth, it's not hearsay. So for example, if a witness says the defendant threatened to kill me, and we are proving the threat was made, not that the defendant actually intended to kill, it's not hearsay. The purpose is not proving truth, it's proving the words were spoken. So in exam it can ask truth purpose or another purpose. The answer is this distinction separates hearsay from non-hearsay uses of out-of-court statements. So three elements. Let's break down three hearsay elements systematically so we can apply them to any scenarios. Element 1, a statement exists. Statement can be words spoken or written, or even conduct intended as an assertion. Nodding your head to indicate yes, pointing at someone to identify them, or any other communication or communicative behavior can constitute a statement. Element 2, the statement was made outside the current proceeding. This excludes testimony given in this trial, but includes previous testimony in other proceedings. Witness statements, letters, texts, social media posts, or verbal statement reported by witness. Element 3, the statement is tendered to prove the truth of its content. This is the critical element that determines whether hearsay rules apply or not. However, statements are not hearsay if tendered for purpose other than providing truth. Classic examples include threats. Proving threatening words were spoken without proving the threat would be carried out. Similarly, contractual terms, defamatory statement, or words showing the speaker's state of mind are often admissible for non-truth purpose. In exam, it can ask, apply 3 elements quickly. Statement, out of court, truth purpose. If all 3 are present, you have hearsay and must find an admissibility gateway. So real evidence. Before analyzing hearsay, check whether evidence constitutes real evidence, which falls outside hearsay rules. CCTV footage, photographs, and audio recordings are typically real evidence. They capture events directly rather than conveying human assertion about the event. The camera or recorder is not making a statement, it's mechanically recording. Automated computer outputs are real evidence. Camera speed reading, like automated banking records generated by system without human input, they are real evidence because no human assertion is involved. The distinction matters enormously. If there is no human assertion, there is no statement and therefore no hearsay. The evidence is simply a thing that exists and is relevant to the case. However, you must still assess relevance and authenticity. Is the CCTV footage from the correct location and time? Is the photograph an accurate representation? Has the equipment been properly calibrated and maintained? And that's one of the objections on speed cameras, speed tickets. These questions affect admissibility and weigh, but don't invoke hearsay rules. In exam, it can ask, is this statement a recorder? So this, if it is mechanical recording without human assertion, it's real evidence outside hearsay analysis, and that's what we need to understand for our exam purpose. So statutory structure. Understanding hearsay requires navigating the statutory framework. The main statute is Criminal Justice Act 2003, which reformed hearsay law comprehensively. So Section 9 statements, technically under the Criminal Justice Act 1967, provide a consent-based route for admitting written statement without calling witness. This is administratively convenient for uncontroversial evidence. Section 114 of CGA 2003 establishes 4 routes of hearsay admissibility: statutory provision preserved or created by the Act, preserved common law exceptions, agreement of all parties, or the interest of justice. The main gateway you shall see are Section 116 and 117. Section 116 deals with unavailable witnesses, situations where the maker cannot testify. Section 117 covers business documents created in the ordinary course of business. Some common law exceptions are preserved, including re gestae, like statements made in spontaneous reaction to event. So in exam, it can start with Section 9 or Section 114. If the evidence is truly uncontroversial or both sides consent, Section 9 is cleanest. If disputed, we need Section 114 and must identify which of the 4 routes apply in here. So, Section 9 provides a streamlined procedure for admitting written statements, but strict requirements must be met. First, the statement must be signed by its maker. There is also a prescribed declaration confirming the truth of the statement's content. Without signature and declaration, Section 9 does not apply. Second, the statement must be served on the other side. Proper service gives the opponent notice and opportunity to object. Third, and critically, any objection defeats Section 9 use. If the opponent objects within 7 days, the statement cannot be admitted under Section 9. The objection is absolute. The court cannot override it. This protects the right to cross-examine on controversial matters. So if Section 9 fails due to objection, you must pursue a different gateway, usually Section 116 and 117, if the witness won't attend. In exam, it can ask, can the court override an objection? No. Section 9 is consent-based. Any obligation ends its availability. This makes Section 9 suitable only for genuinely uncontroversial statements. So, common practical uses, what evidence typically goes in as Section 9 statement. Let's identify common practical uses. Continuity evidence is classic Section 9 material. Police officers explaining how exhibits were handled, sorted, and transported. This is rarely disputed and does not require live testimony. Technical evidence that's not challenged also work well under Section 9. Expert reports where the findings are not contested, calibration certificates for equipment, or similar technical matters. Formal matters including proof of ownership, vehicle registration, or similar administrative evidence where the facts are not genuinely in dispute. Section 9 saves time on uncontroversial evidence, allowing courts to focus on disputed issues. If evidence is challenged or goes to the heart of the case, use another gateway. So that is, it can be asked, is this truly uncontroversial evidence? It goes to contested fact or credibility matters. Section 9 is not appropriate. So if it goes other side, like, if it is contested, of course, Section 9 will not apply. So let's explore Section 114, 4 different ways. Section 114 is a gateway provision listing 4 routes for hearsay admissibility. Understanding these route structure are hearsay analysis. So, Route A, statutory provision preserved by the Act or created by other statute. This includes Section 116, 117, which we will examine. Route B, preserved common law rules set in common law hearsay exceptions survived the 2003 Act reforms, including the Hearsay-like statements and certain public information documents. Route C, all parties agree to admission. If prosecution and defense both consent, hearsay can be admitted by agreement. This is practical and avoids procedural complexity. And Route D, the interest of justice require admission. This is safety valve in allowing court discretion to admit hearsay when justice demands it, even if no specific exception applies. However, this route has strict conditions and is rarely used. So Section 116 and 117 are the core routes you shall encounter most frequently: unavailable witnesses and business document respectively. In exam, it can ask, name the correct Section 114 route, identify whether you are relying on statutory exception, common law, agreement, or interest of justice. So all of it, it will reflect in scenario, and I believe you can easily get it done once you understand these exceptions. Or route, sorry. So Section 116 threshold. Section 116 applies when the witness is unavailable, but before considering unavailability, threshold requirement must be satisfied. First, the person who made the statement must have been someone who could have given oral testimony. They must have been competent at the relevant time. Second, the maker must be identified to the court's satisfaction. You can't rely on anonymous hearsay. The court needs to know who made the statement. Third, the maker must have been capable of understanding questions and giving comprehensible answers when the statement was made. If they were too young, too ill, or otherwise incapable at the time, the statement does not qualify. The party seeking to adduce, hearsay must prove the unavailability condition exists. This is typically determined as a pre-trial hearing to avoid wasting trial time. Meeting 3 threshold requirement is essential before you can even consider whether an admissibility ground applies. In exam, it can ask which threshold requirement is missing. Check the maker could have testified, is identified, and was capable when the statement was made. Missing any element will defeat application of Section 116. So, once threshold requirements are met, Section 116 requires proving one of 5 unavailability grounds. Let's identify them clearly and systematically. Ground 1, that the maker has died and obviously cannot attend. This is straightforward. Ground 2, unfit. The maker's bodily or mental health condition makes attendance impossible or highly inadvisable. Perhaps they are seriously ill, in coma, or mentally incapacitated. Ground 3, outside the UK, the maker is abroad and it's not reasonably practical or practicable to secure their attendance. Distance alone is not enough. You must show genuine impracticability. Ground 4, for example, they don't have visa, they can't come, or they are denied visa, or something like this. Ground 4, cannot be found despite reasonable steps to find the witness. Their location is unknown. Reasonable steps require genuine effort, like checking last known address, contacting relatives, searching databases, all of it. Ground 5 is fear. The maker is in fear and refuses to testify because of that fear. We shall explore this ground in detail shortly because it's frequently involved and invoked and carefully scrutinized. So it can ask in exam, match the facts to the 5 grounds, read the scenario, identify which unavailability ground applies, and articulate why that ground is satisfied. So different grounds have different proof requirement as well. So fear ground, let's talk about it. As we said, the fear ground under section 116 requires special attention because it balances witness protection against fair trial rights. Fear is defined broadly. It includes fear of death or injury, but also fear of financial loss or damage or to reputation. The fear must be genuine and reasonable, not fanciful. However, before admitting hearsay on the fear ground, court must consider whether special measures could enable the witness to testify. Special measures include screens, video links, clearing the public gallery, or giving evidence in private. These measures often address fear whilst preserving cross-examination. The court examines whether special measures would adequately protect the witness. If they would, hearsay admission is not necessary and cross-examination should occur. The burden rests on the party adducing the hearsay to prove fear exists, and special measures would not suffice. This requires evidence, perhaps witness statement explaining the fear or expert evidence about that risk. Crucially, courts focus on fairness to the accused. Admitting hearsay evidence on the fear ground significantly disadvantages the defense by preventing cross-examination, so courts scrutinize application carefully. In exam, it can ask why cannot special measures work here. If special measures could enable testimony, hearsay admission is inappropriate. Let's talk about business documents under section 117. Section 117 provides a gateway for business documents created in the ordinary course of business or another occupations. 3 conditions under section 117 subsection 2 must be satisfied. First, the document must have been created or received in the course of business, trade, profession, or occupation, or as the holder of paid or unpaid office. Second, the person who supplied the information contained in the document must have had or may reasonably be supposed to have had personal knowledge of the matter dealt with. This ensures reliability. The information is not speculation, but comes from someone with first-hand knowledge. Third, if the information was transmitted through intermediaries before being recorded, each person in the chain must have been acting in the course of their business or occupation. This occupation chain ensures systematic, reliable transmission. Examples of section 117 documents include hospital records, bank statement, police intelligence system, automated logs, CCTV system logs, and business correspondence created in the ordinary course of operation. So in exam, they can ask, do all section 117 subsection 2 condition fit? Check business creation, personal knowledge, occupation chain. Missing any element defeats section 117 admissibility. So So some common law hearsay exceptions survived the 2003 Act reform. The most importantly is re gestae. Statement made in spontaneous reaction to event. So re gestae statements are made when a person is so emotionally empowered by event that, faking it or changing it is realistically impossible. The spontaneous emotional dominance reduces the risk of fabrication. So key factors include timing, emotions. Was the maker still under the event's emotional influence? Was it near the event? And opportunity, did they have time to reflect or change? So content, does the statement nature suggest spontaneous, is it spontaneous or not? In Andrew case from 1987, it confirmed that spontaneous statement naming attackers can be admitted as re gestae, even where the maker dies and cannot testify. In WVR case from 2003, it clarified that re gestae statements can be admitted even if the maker is available to testify. Admissibility depends on spontaneous, is it spontaneous, and non-availability, unavailability. Judges assess whether, concoction was realistically possible given the circumstances. If the maker had time to think, reflect, or discuss event with others, that spontaneous thing is compromised. So is concoction realistically possible? That's the question which is asked. So at that point, the answer is this question captures the re gestae test. So concoction is realistically, if it is possible, the statement does not qualify here as re gestae. So traditionally, prior statements by witness who testify could be used to attack credibility, but not as evidence of truth. The 2003 Act changed this under Section 119 and 120. Section 119 deals with prior inconsistent statement. If a witness made an earlier statement inconsistent with their current testimony, that prior statement is now admissible as evidence of the truth of its content, not just to undermine credibility. So this expands the statement's evidential value significantly. Section 120 covers prior consistent statements. Generally, consistent statements are inadmissible because they are self-serving. However, Section 120 creates a limited exception that allows truth use. Statement rebutting suggestions of fabrication, statements made when matters was fresh in memory, or statements confirming witness identification. Use these provisions carefully in credibility disputes. They allow rehabilitation of witnesses through their prior statement, but only within statutory limit. In exam, it can ask, is this Section 119 or Section 120? Section 119 is inconsistent statement, and Section 120 applies to consistent statements. That's the difference. So let's talk about multiple hearsay. So multiple hearsay involves chain of transmission. A tells B, B tells C, C testifies about what B said, B said, A said, all of it. Each link increases distortion risk. Courts generally disfavor multiple hearsay because reliability decreases with each transmission. Section 121 creates strict control. Multiple hearsay is admissible only in specific circumstances. First thing that we need to look at is if both links fall within Section 117 business document, Section 119 prior statement, or Section 120 consistent statement. Second, if all parties agree to admission, agreement can overcome hearsay objections when parties believe evidence is reliable despite multiple links. Third, if the interests of justice requires admission and the evidence has sufficient reliability to justify multiple hearsay, this requires convincing the court that reliability is not fatally compromised by the chain. So it is not compromised at all. Identify the weak link in any hearsay chain. Typically, the point where information transmission was informal, unverified, or subject to misunderstanding. So each transmission in multiple hearsay decreases it unless we got all these elements. In exam, it can ask which link is the weak point, analyze each transmission stage, where did reliability potentially break down. This analysis helps oppose multiple hearsay or assesses its weight at that point or questions its weight. So, credibility safeguard. Section 124 provides a crucial safeguard. The opponent can attack the hearsay maker's credibility even though that person is not present for cross-examination. You can call evidence showing the absent maker's bias or unreliability. Perhaps they have reason to lie, a grudge against the defendant, or a financial motivation to make the statement. You can use prior inconsistencies or inconsistent statements made by the hearsay maker if they have told different versions at different times. This undermines reliability, of course. You can use admissible bad character evidence about the maker if they have convictions for dishonesty or a propensity for fabrication. This is relevant to credibility. You can change accuracy with contrary evidence, other witnesses, documents, or physical evidence contradicting the hearsay document. Statement can undermine its reliability, not document its statement. So, sorry. Section 124 provides a substitute for cross-examination. You cannot directly question the absent maker, but you can present evidence attacking their credibility. In exam, it can ask, how do you cross-examine an absent maker? Through Section 124, call evidence attacking bias, reliability, prior inconsistency, bad character, or accuracy. This protects against unfair hearsay admission. So the next thing is hearsay admission requires procedural compliance. The Criminal Procedure Rules, Part 20, prescribes notice requirement for key hearsay routes. So notice must be given using prescribed form. The prosecution must give notice 20 business days before trial in magistrate court or 10 business days in Crown Court. Different time frames apply depending on court, and try to memorize these time frames. Objection must be filed within 10 business days of receiving notice. Missing this deadline weakens your ability to oppose hearsay admission. These procedures ensure fair notice and opportunity to respond. Surprise hearsay evidence at trial violates fair trial principles. Article 6 of European Convention on Human Rights protects the right to confront witnesses. However, the European Court of Human Rights confirmed that hearsay admission does not automatically breach Article 6 if adequate counterbalances exist, such as careful judicial directions, Section 124 credibility challenges, and Section 78 base discretionary exclusion for unfair evidence. So courts assess whether hearsay admission, despite counterbalances, render the trial unfair. If the sole or decisive evidence is hearsay, heightened scrutiny applies. In exam, they can ask, have notice and objection deadlines been met? Check procedural compliance. Late compliance or late application may be refused, protecting the opponent's legitimate exception of timely notice. I hope it is. Of course it is, but too much, but I believe we need to understand that hearsay is a weak evidence, so courts must be a bit more sensitive on it. The next thing is confession. Oh my goodness. In this country, I hope we are safe, but confessions in other parts of the world, those are horrible. So now let's turn to confession. That confession is any statement wholly or partly adverse to the person who made it. Whether in words or conduct, it needs not to be made to a person in authority. Confession to friends, family, or cellmates, it qualifies as confession. Defendants have rights during police interview, legal advice, being informed why they are arrested, and various base safeguards we have already talked about. These rights protect against coercion or unreliable confessions. Confessions can be excluded under two provisions. Section 76 of PACE provides mandatory exclusion if obtained by oppression or in circumstances making them unreliable. If the defense raises this, the prosecution must prove beyond reasonable doubt that the confession was not so obtained. Section 78 of FACE gives courts discretion to exclude evidence if admission would have such adverse effect on trial's fairness that it ought not to be admitted. This is very broad. Of course, this broader discretion catches unfairness not covered by Section 76. Confession is a big thing, so it should be dealt with big sensitivity as well. So admissibility is determined through a voir dire. A trial within a trial without the jury present, the jury only hears the confession if the judge rules that it is admissible. If the defense argues that confession was not made at all, not just that is not inadmissible, this is decided by the jury under the Fleming principle. So, once in exam it is asked, run Section 76 first, then Section 78. Section 76 is mandatory exclusion with specific ground, and 78 is discretionary on court's discretion. So let's start our favorite slide, SQE tips and pitfalls. For hearsay analysis, always start by asking, is this standard for truth? If not, it's not hearsay. Check whether evidence is real evidence before analyzing hearsay. Section 9 fails if there is any objection. Remember, it's consent-based and the court cannot override objections. Section 116 requires a specific unreliability ground from the 5 listed. Don't just say unavailable. Identify which ground applies. Fear requires consideration of whether specific measures could work. 117 demands proof of all 3 conditions: business creation, personal knowledge, and occupational chain. Missing any element defeats admissibility. Hearsay needs both timing and emotional dominance. The maker must be so emotionally empowered that concoction is unrealistic. So, use Section 119 and 121 precisely. Don't confuse inconsistent and consistent statement, and recognize multiple hearsay requires special justification. Use Section 124 to attack absent maker credibility. This is about substitute for cross-examination. For confession, Section 76 has mandatory exclusion grounds, oppression, or unreliability. The prosecution bears the burden of proving beyond reasonable doubt the confession was not obtained through these means. Keep oppression and unreliability categories separate. They have different tests. So Section 78 provides broader fairness discretion. Even if Section 76 does not apply, Section 78 might exclude if admission would unfairly prejudice the defendant. Voir dire procedure excludes the jury. Only if the judge rules the confession admissible does the jury hear it. However, if the defense argues under Fleming that the confession was not made at all, this goes to jury. Off the record admissions need Code C compliant recording afterward to be admissible. Mixed statement, partly adverse, partly exculpatory, must be admitted whole. You cannot cherry pick the adverse part and leave the other part. So I hope this helps you understanding hearsay and confession. And of course, it is a bit area that requires sensitivity, not only in courts, but also in understanding. And if you understand it, if you like this session, I would request you again to subscribe it and share it with your friends. I wish you all the best. Ta-da!